My name is Chris Brown. I am a lawyer with my own firm here at Venture Legal. It is 2 o'clock on a Friday. I don't know where you all are at, but I'm in Kansas City. It's beautiful outside. So I'm going to ask you, I can't see you, but I'm going to ask you to raise your hand if you're super excited to talk about legal topics. I'm probably the only one raising my hand, but this stuff is really fun to me, and I hope this will be a helpful session. So, a little bit of background on me. So I started I started in the music business actually back in 2005, and I graduated from UMKC Law School in 2010. Kind of an odd transition there, going from music business to law, but I was really interested in intellectual property, which is why I decided to go to law school. After a while of working at a traditional firm, I kind of got bored, so I went out and created my own law firm in 2014 called Venture Legal. Through Venture Legal, I represent tech startups, freelancers, and small businesses. So I have a lot of creative clients, a lot of website developers, marketing professionals. So that's really why I was interested here in speaking at Flyover Camp. Related to all of this, in 2020, I launched a platform called Contract Canvas, which is a digital contract platform for creative professionals. It's just a way that you can go online, create your own contract. It's what we call a human readable contract, so it has icons in plain English. And I think it's a much better way for creators, including web developers, to create their contracts. So that's been live now for about 9 months or so. It's been an interesting year to launch that. Before I get into the legal topics, I just want to say, don't do anything stupid. This is obviously a public event, so if you put anything in the chat box, other people can probably see it. You probably shouldn't spill the secret sauce of your business, your client's confidential information here. It's also general legal advice. I'm not your lawyer. Some of my clients might be here today, but this presentation falls outside of that normal attorney-client relationship. We're going to cover 5 things today, hence the name of the presentation. We're going to talk about starting an LLC or a corporation. We're going to talk about business, finances, and tax, dive into intellectual property, hiring people, and for most of you, that probably means independent contractors, and then also kind of go deep into Contracts 101, since I think for most of you, that would probably be the most helpful thing to talk through. In the meantime, while I'm talking, feel free to throw questions over in the chat box. I'm pretty sure I can see them. I really like having a dialogue. One of the things I like about doing events like this is talking to the people in the audience. And so it's kind of hard to do here, but of course, if you have questions, please put them in the chat box. You don't have to wait till the end. Just do it whenever you have the question come up. So, oh, I keep clicking in the wrong place. I have to click over here. Or maybe I'll just do that. Okay, so the first topic is choosing the right business entity. My guess is that a lot of you probably operate as freelancers, which is a really good way to operate. I myself am technically a freelancer. I'm just a solo lawyer, which is just a fancy way of saying freelancer. Lots of benefits to being a freelancer, lots of negatives as well. But the technical term for a freelancer is just a sole proprietor. So that's the woman sitting there on the cloud working away on her computer. Sole proprietor, one person. The biggest downfall to being a sole proprietor is that you're going to be personally liable for everything that you do through your business. And if you have subcontractors, you're going to be personally liable for everything that they do through your business as well. And that's really the biggest drawback here. So imagine you're creating a website for somebody or an application or whatever it might be, and you hire a subcontractor to come in and maybe they write a bunch of content that goes into the app that you're working on. Well, the problem is if that content is infringing somebody's copyright, then your client can sue you because of the action that your subcontractor did. And the worst part about that is that you're going to be personally liable for everything, right? So they can sue you, they can put claims against your house, your car, they can garnish your wages, and it's just really not a very good way to operate a business. Now, there's lots of reasons to be by yourself, but you can also be by yourself in a different format, which we'll get into here in a few minutes. There's another form called a partnership, and you can actually create this without filing anything with the government. If Lauren, I decide to start up a business and she's going to do all the development and I'm going to do all the design or something. And we say, let's go out and build a website. And we say, we'll charge $5,000 and hopefully we make a profit. Well, what we just did is we created a legal partnership, and it's a legal business entity and people can sue it. It can sue people. Laura can sue it, I can sue it, we can have partnership disputes, but we're both the owner of that legal business entity. The biggest downside here, though, once again, kind of like a sole proprietorship, is that you're going to be personally liable, again, for everything that happens through the business. So Again, the same idea. You know, say Laura creates this awesome app, but I write all the copy. Company gets sued for copyright infringement. Laura would be on the hook for all of the liability. Again, personally liable. So ideally, you don't want to operate as a sole proprietor in a partnership. Partnerships can actually be a lot worse than sole proprietor. If you're only doing 1 or 2 projects a year, sole proprietorship might be okay, especially if the risk is low, but it's not ideal. The better thing for you to do is to create an LLC or a corporation. And that's what that little cafe image there is on the side. When you do that, what you're doing is isolating yourself from liability. So the name limited liability company, I mean, hence the name, it provides limited liability. And what that means is it provides that limited liability to the owners of the business. So you've got these 2 people up here on top who are operating that cafe. If the cafe gets sued, maybe they've got a too hot coffee or whatever that gets served, the cafe can get sued. The cafe can be thrown completely under, go bankrupt, so on and so on. But unless the owners were actually involved in whatever the negligent action was, they shouldn't be personally liable for what's going on, for the liability owed to that third party. So that's what you get when you create an LLC or a corporation. And you can see that I've got that little line going around the business. That's kind of what that is meant to represent. Now, the owners can still be liable if they sign personal guarantees, like on a bank loan or a lease agreement. They could still be liable if they're the ones who caused the slip and fall or whatever it might be. But you can still isolate yourself from a lot of liability by forming that LLC. You might be wondering, what about S-Corps? And if we have any accountants in the audience, I can say that they probably love S-Corps. I love S-Corps, actually. I myself am an S-Corp. But an S-Corp is not really a business entity. So if I go back to this slide here, you see S-Corp doesn't fall in because it's not a business entity. It's just a tax classification. And what I mean by that is if you are if you're an LLC or a corporation, I don't think you can do it as a sole proprietorship. I don't remember, but you can file a 1-page document with the IRS and elect to be taxed as an S-Corp. And the details of that are probably too deep for us to get into today, but I can basically say in summary, by doing that, you can save about 15% on your taxes. Kind of sound like Geico here, but you save about 15% on the profit that you earn. You still have to pay employment taxes and other kinds of taxes, but you can actually save a lot of money by doing it. But there's a lot of downsides to doing it. And before you make that election, you would want to talk to an accountant and also a lawyer to make sure that you're not making the wrong move. So then the question that I get the most is, should I form an LLC at all? And if so, should I form an LLC or a corporation? And, if you're operating as a web developer, app developer, whatever it might be, an LLC is not required by any means. You can totally do a sole proprietorship, like I mentioned earlier. But if you're doing more than a couple of projects a year, and certainly if you have anybody who's working with you on client matters, it's really important to form an LLC so you can get that liability shield. And at that point, you have to choose, LLC versus corporation. And I can say the vast majority of businesses today will form as an LLC as opposed to a corporation because they're just so much easier to operate. There's a lot less corporate formalities. You can choose how you want to be taxed. You don't have to have annual meetings. Most states, or at least some states, don't require annual reports. So there's a lot of benefits to doing that. The only reason I would suggest the corporation is if you have a really complicated ownership structure. And if so, it's probably related to raising venture capital. So if you're raising some kind of investment, there's a possibility you might want to be a corporation. Really, aside from that, there's not a lot of benefits to being a corporation, at least not now in 2020. So let's just assume that you want to form an LLC. And if you want to form a corporation, you'll follow steps that are pretty similar to this. The documents are just a little bit different. So the first thing you do is file articles of organization with your state's Secretary of State. Missouri charges $50 and Kansas charges $160. And I don't know other state fees, but those are the 2 that I work on the most. You usually form it in the state that you operate. So I live and work in Missouri, so I formed my company in Missouri. But you could form in a different state if you had a reason to. A lot of tech startups, especially if they're raising venture capital, will form in Delaware, and there's various reasons for that that are probably not worth discussing here. But for most freelance developers, forming it in your own home state is probably the easiest way to do it. You also have to have a registered agent. That's a place where lawsuits can get mailed. It's a little bit more complicated than that, but that's the summary of it. So once you file that, you get what's called articles of organization. Then you have to draft an operating agreement. So an operating agreement is the document that governs the company's operations. And if it's just one person, it can be simple. I think my operating agreement's 3 pages because I'm the only owner of my business. But if you have more than one person, the operating agreement can be a lot longer and usually will be. So it'll cover things like management rights, economic rights, transfer restrictions, what happens if somebody dies, non-disclosure obligations. It goes through all those various things that the owners have to agree on. So then once you have your articles in your operating agreement, you can take that, you get those 2 things first, then you get your EIN from the IRS. That is an employer identification number, and you use that to identify your business with the government, with banks, and various other people. You usually get that online. So you take those 3 things to your bank, and you can open up a bank account. Speaking of opening a bank account, it's important that you keep your business separate from you. If you don't do this, a court could, in theory, invalidate your LLC and come after you personally for liability, whether it's copyright infringement or breach of contract or whatever. So in order to do that, one of the things you want to do is open up a bank account, which those last 3 documents that I mentioned on that last slide are the things you'll need to open a bank account. And then use that bank account, have your clients pay you into that bank account. Use that account to buy your expenses, your computers, paying contractors, and so on. Then you also have to register in foreign states. So if you operate in more than one state, it's a good idea. Actually, it's required that you register in those foreign states, but this can be tricky for developers who I can imagine you might live in Kansas City and have a client in New York or California or wherever. So the question is, do you have to register there? And it can be hard because if you only have one client there, it's probably not worth it, but the state might want you to anyway. It really depends on the individual state laws as to whether or not you have to. And then lastly, file annual reports. So this is for any state that you are registered in and also your home state. So for example, in Missouri, corporations have to file annual reports, but LLCs do not. In Kansas, both corporations and LLCs have to file annual reports. So that's the intro to how you actually start the business itself. Next topic can be extremely boring, but it's really important. And I think that if you can get the basics in place, it saves you a lot of time in the long run. I usually recommend people set up all of their finance and tax stuff with an accountant on day 1 of forming their business, just so it's all set up properly. And then thereafter, it usually can be fairly easy to maintain. So there's 2 ways that your company might be taxed. The first is called pass-through, and the second is called double tax. These are just informal names, by the way. Most businesses in America are going to be pass-through. That's what you would have for sole proprietorships and partnerships, and most LLCs and S-corps would be classified that way. The double tax structure only applies if you're a C corp. So what this means is if you're a pass-through entity and you make money, so your client pays you 10 grand to make a website. Well, ignoring expenses and everything for a second, what you would do is report that $10,000 on your personal tax return, and you would pay income tax based on your personal tax rate. The company itself doesn't pay any taxes on that. Conversely, if you're a corporation and you get paid 10 grand, what happens is you take that 10 grand, the company itself, the corporation has to pay taxes on that. So you just say it's 20%, so you'd pay $2,000 to the government. Then when you distribute that money out to the owners, you have to pay taxes again on that. So let's just say you pay another 20%. Now you're only left with $6,000, which is not as ideal. So that's why most companies choose to be a pass-through entity, usually an LLC taxed as a partnership or a sole proprietor. That's probably the most popular. So here's some practical thoughts on pass-through entities. The first thing you want to do is save a portion of all of your profits. So I usually recommend 15 to 30%. It's something you should probably talk with your accountant to nail down the exact number. But if you take 10 grand in profit from a website, you should take about 15 to 30% of that and put it in a special savings account for tax purposes. Then you pay quarterly taxes. So roughly every 3 months, I say roughly because it's not exactly every 3 months, you pay an estimated payment to the state that you're working in as well as the IRS. And then at the end of the year, you'll pay up either a little bit more if you underpaid, or you'll get a refund if you overpaid. And the way you know that is you do that reporting step, which is that last one there. And what I mean there is you attach a Schedule C or a K1, depending on how you set up your business, to your personal tax return. Of these 3 bullet points, the bullet point number 1, save 15 to 30%, is by far the most important. You don't want to operate your freelance development business for a year and then have tax season come up and realize, oh my God, I owe the IRS 15 or 20 grand and I don't have it. That can be a big problem. So saving is by far the most important thing to do there. And then also a few practical thoughts on how to do finances. First of all, choose a bank that works like you. Some banks have great online technology, have great apps and so on, and others don't. Some have great lending options and others don't. Some have checking accounts with fees and others don't. Point is, interview a few banks. I didn't interview banks when I started, and I kind of wish I would have. And I'm going to actually be changing banks soon because I found a bank that operates better and more in line with how I operate. You should use a cloud-based accounting platform, so you can use something like Xero or FreshBooks, QuickBooks. They all offer cloud-based solutions. And doing this just makes it easier for you to keep your books clean. And if you set it up properly on day one, it's relatively easy to keep clean moving forward, or you can also pay a bookkeeper to do it for you. And then that's the third bullet point, which is don't stay behind. It's easier if you do this, every couple weeks or so, or at least monthly. I'm set up now where I do it every other Monday. I run payroll and balance all of my books every other Monday. And so it's just kind of an easy, seamless process, but I've been at it for 7 years. So it takes a while to get into that flow. All right, now we're going to talk about probably my favorite topic, which I mentioned earlier is why I went to law school to begin with, which is intellectual property. And just as a reminder, if anybody has any questions, be sure to be throwing those over there in the chat box, and I could try to address those. Okay, so intellectual property, there's basically 4 types. There's copyrights, trademarks, trade secrets, and patents. I'm actually going to go backwards on that list because for this audience, I imagine copyrights are your most important. Patents will protect inventions and a few other things. And I doubt most of you are inventing things, so it's probably not as relevant. But if you think you invent something new that solves a purpose or has a function, then you should talk to a patent lawyer. They have really strict deadlines for when you have to apply if you want to seek protection. Trade secrets are important to protect your confidential information. But not only your information, but the information coming from your clients. And so I can imagine that you might be building apps and websites for people, and those clients might tell you, look, I'm giving you all of my secret sauce. I don't want you to spill the beans to anybody. So you would want to have a non-disclosure agreement in place with any subcontractors that you're working with to make sure that that information is protected. And your client would be smart to have a non-disclosure agreement with you to protect their info. Conversely, if you have confidential information that you're giving out to people, you'll also want to have an NDA that protects you, and you can actually use a mutual and non-disclosure agreement that basically works both ways. It can be unilateral, in which case only one party agrees to protect the info, or it can be mutual for both parties. Trademarks is the next area, and trademarks will protect your branding elements. This is your name, your logo, your taglines. You can even protect sounds and scents and colors, like the lion that roars at the beginning of the movies. I think it's MGM. I could be wrong on that, but whoever that is, that roaring lion sound is actually a trademark of that company. And then I think other companies like Tiffany Diamonds and UPS have trademarked their colors because they're so well known. Anyway, trademarks, you will get rights as soon as you start using a trademark in commerce, but it's usually a good idea to register your trademark with the United States Patent and Trademark Office. And doing a federal registration, it gives you nationwide trademark rights. So it's a good idea to do that, but you don't always have to do that on day one. And so the things that you might trademark might be your name. If you have a slogan or a tagline, you might trademark that as well. You could trademark your logo, but the logo is probably not as important for most people. A trademark will last for as long as you use it, and there are some renewal filings that you have to make along the way, but the point is you can protect it basically forever as long as you continue to use it. Copyrights, on the other hand, they don't last forever, but they do last a long time. Copyright will protect creative works, and for most of you, this is probably what matters the most. Copyrights protect music, movies, art, books, all kinds of stuff, but it also protects computer code, which is very relevant to all of you. So front end, back end, pretty much all the different code that you're writing, CSS, HTML, all that stuff is going to be protectable under the Copyright Act. Copyrights last for the life of the author plus 70 to 90 years, depending on the type of work that it was. So for our purposes, that's kind of forever. And it might get extended sometime in the near future because the Mickey Mouse copyrights are about to come up for expiration again. The reason that the copyrights last as long as they do is because Disney lobbied for that in the 90s and was able to get extensions for copyrights. So the biggest question that you have to ask, oh, my clicker doesn't work again, is who owns the copyright? So most of you, I presume, are working for somebody else, either as an employee or as an independent contractor. The default rule for copyright ownership is that whoever creates the work is the owner of that work. So in the context of this presentation, I created it. I created that background image of the different purple colors, whatever. So to the extent that this presentation is original, me, Chris Brown, would be deemed the owner of that work. But there are 3 exceptions when somebody else might be deemed the owner of the copyright. The first one is easy. It's it's an assignment in writing. So if I put down on a piece of paper, I, Chris Brown, hereby assign to Laura my presentation and the copyright to it, and I sign it and give it to her, then she would be deemed the owner of that copyright. That one's pretty simple to get. The second one is if it's created by an employee within their scope of employment. And this one actually applies to me here. So I'm technically an employee of my law firm. Everything that I make that is within the scope of my employment, which is being a lawyer and promoting my firm and so on, is going to be deemed and owned by my employer, Venture Legal. So this presentation would technically be deemed owned by my law firm. The third exception is the one that matters the most, probably because it's the one that people get confused the most. And it's when an independent contractor creates something for their client. It gets to be tricky as to who owns it. So this, though, this exception only applies if there's a written agreement. So if Laura's out there, and I'm sorry, I keep picking on Laura. Her name's just the only name I see up there. But if Laura's out there making something as an independent contractor for her client, and they don't sign anything, Laura's going to be deemed the owner, right? Because that's the default. The creator owns the copyright. The client, of course, probably wants to own that work, though. So what normally happens is there's going to be some kind of a contractor agreement or a client agreement of some sort. And in that agreement, it would say, Laura hereby transfers to the client all of the works, copyright, and so on that she makes. So it gets tricky, and I don't have it here, but I'll come back to it a little bit when I'm talking about contracts as to how you might actually define that. But the key point here is it's important to clarify in the agreement when it's a contractor relationship, who's going to own the copyright. All right, next up, hiring employees and contractors. So, all right, so when you hire an employee, most of you have probably had a regular job at some point, regardless if you're a freelancer now or not, but you're probably accustomed to the employment relationship. So when you hire an employee, you're gonna have a lot of control over that person. You can say, I need you to show up from 9 to 5, here's your office, here's what I want you to work on. I don't want you to work on these other topics. Here's a computer, here's a desk and a chair and all that stuff. Sorry, I got thrown out there for a second. So anyway, you have a lot of control over that person. On the downside, you usually have to pay for expenses and other things for that person. So, I mentioned having an office, having a laptop, and so on. An employment relationship typically involves having tax withholdings and a W-2. So, you get your paychecks, say your paycheck's for $1,000. The reality is you only really get $800, right? Because they take out roughly 20% or so for various taxes. So as the employer, it would be your job to do that withholding. And then at the end of the year, you issue that employee a W-2 to report their income to the IRS. So that's the traditional relationship. And you can absolutely hire employees. But in my experience, most people who are operating small businesses and especially freelancers, you're not likely to hire an employee. You're more likely to hire an independent contractor. So an independent contractor, you're going to have a lot less control over. When somebody hires me, for example, I am an independent contractor to that person. So they don't really tell me when I work, how I work, whatever. All they care about is what do I deliver at the end of the day. So if they ask me to draft an employment agreement for them, or let's ignore that, it's probably a bad example for this slide, but if they ask me to file a trademark for them, they can't tell me when I file the trademark. I could do it at 2 o'clock in the morning or 2 o'clock in the evening. I could do it at home or a coffee shop or wherever. I also, as an independent contractor, would be responsible for all of my own equipment, my office, all of that stuff. So independent contractors, you're not going to have as much control over, but the benefit of that is you have a lot less reporting obligations. So you have to file 1099s and W-9s for contractors, but that's a lot easier than dealing with employment withholdings, where you're taking money out of their paycheck every time you pay them. So what happens is you should request from your contractors what's called a W-9, and that's a fairly simple one-page IRS form that includes their tax information. And then at the end of the year, if you pay them $600 or more, you have to issue them a 1099. And that is another IRS form that tells the government how much you paid that person. Then what the government will do is take that 1099 and then go look to see if the contractor reported the income. And if the contractor didn't report the income, then eventually they'll catch up to it and require back taxes for it. With employees, you don't necessarily have to have an employment agreement, but it's a good idea to. But the thing that you definitely want to have for independent contractors is a contractor agreement. And the biggest reason being, coming back to a couple slides ago, copyright. Because if you hire an independent contractor, again, you will not own the copyright in what they're creating unless there's something in writing, usually a contractor agreement that says that you own it.
Hey, Chris, really quick, off for a second.
Oh, okay.
I want to make sure you got a chance of the session chat. I think we did have a few questions from
great.
Eric. Yeah.
Oh, here they are.
You just scroll down a little bit. Yeah, you're good.
I didn't see them coming in. Okay, cool. Thank you so much, Laura. Let me just hop back up and see if I can catch up to some of those. Okay, yeah, I guess I was on the wrong chat screen. Okay, here. Oh, Eric was asking me about how long I've known him on Twitter. I think that might be private for me. We'll get back to Eric. Let's see here. John's asking about SCorps. Do you need to do payroll yourself? Yes. So a while back, I had mentioned an SCorp is just a tax election. And when you make an SCorp election, what you have to do is run payroll for yourself. You cannot be an SCorp if you're not paying yourself payroll. And that actually ties in with what I was just talking about, which is you have to do employment withholdings. So that's one of the hassles of being an SCorp, is doing the employment withholdings and doing a tax return for the business itself. So if you're making a bunch of money, more money, I shouldn't even say it like that. Let's just say that you are a lawyer and you make 50 grand in income in a year. It's probably not worth making an SCorp election, because a lawyer's probably going to make 50 grand or more in salary. But let's say you're a lawyer and you make 150 grand a year in profit. Well, at that point, it makes sense, because you can probably pay yourself a salary, which is taxed entirely, say 75 grand salary. The other 75 grand you can take out and not pay employment taxes on. So I mentioned you could save 15%. That 15% savings comes in on the profit above your salary. So it gets really deep. What I'd recommend is, if you're interested in doing that, talk to an accountant, because they can run the numbers and tell you if it makes sense to become an SCorp. Eric is asking about QuickBooks for accounting. So I've never used QuickBooks. I've got some accounting friends who love it. I also have some accounting friends who hate it. I think QuickBooks is somewhat legacy. They're a little bit older school. With that said, I've heard good things about it from certain people who think it's super easy. I use a company called Xero, which is Xero.com, and they're super easy to work with. I'm actually looking at switching to FreshBooks though, because FreshBooks makes it easier to collect ACH transfers. And right now I'm paying a ton of money to Stripe to collect credit card fees. And so I'm thinking about switching to FreshBooks. But anyway, I think QuickBooks, FreshBooks, and Xero are all pretty comparable. I think they're all about the same amount of money. The point I'm really trying to make is that you should sign up for at least one of them, because trying to do it in any other way, like an Excel file or shoebox with receipts, is not a good way to do it. Cost for a patent search or trademark search. I don't know about patent searches. I don't practice patent law. Patents can be extremely expensive, so I'd probably avoid, or I should probably not give too much thoughts here in terms of what that would cost. But I can tell you a trademark search, depending on the firm you go through, it's going to be $500 to $1,000. Could be a little bit more. Certainly some larger firms might charge more. I typically do it in the $750 range, and that includes a third-party fee that I pay to run the search. It's a good idea to run a search like that to see if anybody's using your name, but certainly not. You don't necessarily have to do it on day one. I mean, if you've got enough money to process all these legal fees, by all means, do it up front, but you could always do it later. John's mentioning that he's been using QuickBooks for years, only because most CPAs support it as opposed to others, which is totally true. You should talk to your accountant before you pick your accounting software because like for example, mine got me into Xero, so I can just give access to my accountant in the platform. But if my accountant didn't understand Xero, it would make it harder. So definitely talk to your accountant. Let's see here. But Laura says she's happy that she's owning everything in all of the examples. Okay, Monique's saying, as an independent contractor, how do I report for my taxes? That gets back to, let me just fly back there really quickly. I already went through this, but I'll do it really quickly again, and you can definitely get these slides later. What I would do is say 15 to 30% of your profits, put it into a special savings account just so you have it when tax time comes up, and then you pay estimated and quarterly taxes to the IRS and also your state government. And then at the end of the year, you attach a Schedule C or a K-1 to your personal tax return. The thing I would say here, because this is obviously not going to give you the exact knowledge of how to go do it, talk to an accountant and get them to set you up on the schedule, and then you just basically follow their instructions. And then lastly, somebody said Expensify is such an amazing tool as well for keeping track of expenses. I've heard that. I don't use it. Xero, the platform I use, they have an app, and I can take photos on my phone of receipts and save them and stuff like that. But yes, Expensify I've heard is awesome. Okay, now that I can see your chats, I'll keep up as we go through live, and let me hop back to where we were. Oh, the last topic's contracts. Who's excited to talk about contracts on a Friday at 2:30 when it's sunny outside? Me. So to create a contract, there's really only three things that you need. You need offer, acceptance, and consideration. What that means, and let's go back to my examples with Laura again. If Laura says, hey, I'll build you a website for $5,000, and I say, great, sounds good, I accept. Even if I don't say accept, if I just say, awesome, sounds great, get started. We have a contract. That's it. That's all you need. Laura's offer, to build it, is her offer. My acceptance was me saying, yep, get to work. And then the consideration part of that, that word is just a fancy way of saying something of value. What Laura is providing that is valuable is the service of building the site. What I'm paying, the cash, is my consideration. That's the thing of value that I'm putting in. At that moment, we have a legally binding contract. If she does it and I don't pay, I can sue her for breach of contract, among other claims. If I pay her and she fails to deliver, I can sue her, and so on. So anyway, you don't need a written agreement. That's the thing that catches a lot of people off guard. With that said, using a writing is always a good idea because it just helps on so many different levels. It helps you to get on the same page with your client or the other party before the relationship begins. If a dispute arises, you can go back to the contract. And really investing the money and the time in a contract up front will save you a ton of headaches later in case a dispute arises. If somebody comes to me and they're like, I've got this dispute, and I say, how much is it worth? And they say $6,000. I say, yes, you can sue for $6,000, but honestly, you're not really going to want to. Most of the litigations I've been involved with, and I don't do a lot of litigation, but the small times I've been involved with it, it's hundreds of thousands of dollars. And so, contracts are just super helpful to help you try to get out of that, to not get out of it, but to help you avoid getting into the situation where the dispute arises. There's two main formats that I see out there. The first one is single project agreements. And this is just simply where you say, hey, I'll build you a website. You pay me $5,000, sign on the dotted line. The agreement itself says who owns the works and an NDA and all that stuff. And then if you come back later and say, hey, you know what, I can host your website now and do monthly maintenance. Well, okay, another contract, get that out, sign the contract, and you now have two contracts. But there's another format that works better in most cases. And that example I just gave is a really good example for why this works. It's the MSA and SOW format. So an MSA is the master service agreement. And that agreement doesn't really require either side to do very much. It just says, hey, we're going to work together. We're going to protect each other's confidential information. Anything the developer makes will be owned by me, the client, and so on. It goes through the legal terms. Then you do one or more SOWs that are project specific. So in the case that I just gave, somebody says, I'll make you a website. So you do SOW number 1 that says, I'll pay you $5,000, you build me a website. SOW number 2 might say, now I'm going to maintain it and you're going to pay me, I don't know, $100. Somebody asked statement of work. Yes, SOW stands for statement of work. Some people call it a scope of work. Anyway, SOW number 2 would say, I'm going to pay you $50 a month to maintain my website. You can come back and do a statement of work number 3, later to build a mobile website or whatever it might be. But the beauty is those SOWs can just be one page. You don't have to or they can also be a lot longer than that, but they don't have to include all those legal legal terms because it's governed by the master agreement, right? So the master agreement sits up here, then you got a bunch of SOWs underneath it. I've got a bunch of essential terms in here, and I'm not going to go through each one individually. I put a lot of it in here just because I presume that you guys can access slides later at some point, and I just wanted to have it in here. But I'm going to fly through a few of these quickly and spend a little bit more time on other ones. And these are terms that you should just basically have in pretty much all contracts. So the first thing is the parties. Who are the parties to the contract? So you state this in two places. You put it at the very top in the preamble. And that's usually where it says, this client agreement is between Venture Legal and Eric, right? And then at the bottom, you put it in the signature block where you're actually signing your name on the contract. It's important to get your name correct. So if you operate as an individual, you just use your legal name. Technically, you should use your legal name, on file with the IRS. So for me, that would be Christopher Brown. You don't have to do that technically. I use Chris Brown an awful lot. But if you operate a business, it gets a little bit more complicated, and you absolutely need to use your LLC name or corporate name or partnership name, nonprofit name, whatever it might be. So at the top, you print that. At the bottom, you sign it like this. If you're signing as an individual, you just simply sign your name, print your name. If you are signing for a business, you print your business name first, sign your name, print your title. Your title is just whatever you call yourself. It could be owner, president, CEO, whatever. For LLCs, it's usually going to be managing member, or sometimes just member. If you don't do it like this, then you might be deemed the party to the contract, even though you didn't intend to be, like as an individual. Services and payments, I'll just highlight quickly and say, you need to be as clear as you can, right? So you wouldn't want to say, Gene will build a website for Bob. I don't know what the hell that means. How many pages? Are there going to be videos, photos? How much content will be on those pages, right? Is it going to be WordPress or something else? You need to be a lot more thorough. The same thing for payment, right? Bob will pay Gene $2,000. I have no idea what that means, right? Is it $2,000 up front, $2,000 at the end? Is it going to be invoiced? Is it payable online? What about expenses? What if you have to buy a theme, and so on and so on? Point is, be as thorough as you possibly can on all of those service and payment terms. Intellectual property, I already mentioned this a little bit earlier. It's important to explain, who's going to own the intellectual property, and if the client is going to own the IP, it's important for you to get portfolio use rights so that you can put it, on your website and your marketing materials and so on. And then also, if your client's going to own it, consider whether you need to own any of the underlying core assets. So if you're a web developer and you built out your own themes, for example, and you use those themes on multiple client websites, you cannot transfer ownership of the underlying core assets to your client, because then you don't own them anymore and you can't reuse them for multiple clients. So it's important to think about how your agreement needs to be worded to say that you retain ownership of certain things and give them a license to those things. And then all the unique stuff that you create, maybe you give them ownership of that. Confidentiality, I mentioned earlier, is a form of intellectual property, and usually this will be housed inside of a contractor agreement or client agreement. You'll want to think through, is it unilateral or mutual, meaning do both sides have to protect info or just one side? You'll want to think through the main three obligations, which is 1, to protect the information, 2, don't use the information without authorization, and 3, don't disclose it outside to other people. And then you'll also want to think through, what is confidential? You usually would define that in some format. You could create like a list of everything, or you could also just say, information that a reasonable person would deem confidential. And then you want to include exceptions. So there are reasons why you might want to disclose something. So you should be able to have the right to disclose it to your employees, maybe to a court if you get a court order, and so on. And then also exceptions to what the definition is for confidential. So confidential information usually accepts things that are already in the public domain or that you create on your own. And then lastly, consider the length of the obligations. So sometimes you'll see that this runs forever, but more often I see obligations that usually run for like 5 to 10 years. It just kind of depends on the nature of the information. Somebody asked if I have a boilerplate contract. I don't, but I'll come back to that here in a couple of minutes because I've got a couple tips on that. Term and termination, you'll always want to look at how do you get out of the contract. Can you terminate early? Can they terminate early? And if so, what happens? Do you have to give over the files? Do they have to pay you any money? Do you have any kind of cancellation fee, and so on? And then last, how do you review a contract? So if somebody else sends you a contract, which happens all the time, here's what I like to say. And it's funny, I say 5 high-level steps. Used to be 5, I cut it down to 4, and I didn't update my slide. So I'll have to do that later. So step one is, what are your expectations? You want to make sure that you know what it is that you're getting into. And if you're having a lawyer or somebody review it for you, it's important that they know, what are your expectations for the deal. I like to review the key deal terms first. So this is usually payment and services, and often ownership of IP. And then I read everything else. And seriously, you do have to read everything, because there could be something tucked away in section number 36 that you just didn't realize, and it could have a really bad effect on you in the future. So then consider, is anything missing, or does anything need to be changed? And if so, you have to consider your options of how to do that. So I'll kind of bounce a little around this slide, but I recommend you use track changes in Word or Google. Google Docs has, I think it's called suggestion mode. Word has its track changes feature. And then also try to keep their language whenever possible. Unless you have to, it's a good idea not to delete entire sections and rewrite them. Just try to massage the language a little bit to get it to be more favorable to you. But in all cases, ask questions. So if the other side is proposing a contract, first of all, if you don't understand something, or if it just doesn't seem like it fits the contract, just ask. I can't tell you how many times somebody's like, oh, whoops, I didn't mean to include that in there. Or no, that's not what we meant at all. Our lawyer got it wrong, or we got it wrong. So don't assume anything. Ask questions if you think things are strange. But then at the same time, understand your bargaining power. If Google is hiring you to build something for Google, you're going to pretty much have to sign their contract as is, or turn it down. Same thing for other places, even around here like Cerner. It's really hard to negotiate Cerner and other large employer contractor agreements. But conversely, if you're building a website for the bike shop down the street, it's going to be a lot easier. Or I shouldn't say easier. You'll have a lot more bargaining power to make changes. Okay, so Miles was asking about boilerplate contracts. I don't have any boilerplate that I just give away necessarily, because it's too complicated. But I do have Contract Canvas, which is my digital contract platform online. In fact, I've got a checklist on there, which is what this is talking about here, where you can go through this checklist whenever you want to review a contract. Contract Canvas also has an ability for you to go in there and create contracts for your clients to review and sign digitally, and it's a much easier way to do it. So it's more of a SaaS platform and less of a hiring a lawyer. And then I also do, well, actually, and I should say, there is a free contract on there. It's pretty basic. I think it's only 1 or 2 pages, but you can download a free contract on contractcanvas.com if you want to. And then I also sell more thorough agreements through my law firm website, venturelegalkc.com, where you can pay and download employment agreements, client agreements, contractor agreements, things like that. Those are certainly more thorough, but they're not free, of course. I think that's all that I've got. I went through all that stuff pretty quickly, but those are the 5 topics I think are most important to you. I'm going to put my info here, and of course, if you have questions, put them in the chat box real quick, and I'll address them before we go.